Hey learners, I'm here with a very important topic, Lego system. Make sure you pay much attention and get something. The subtopics that we're going to look at are A. Elements of a good legal system, B. Sources of law in Zambia, and criminal and civil cases. Those are the three subtopics that we're going to look at this time. Let us first understand the legal system. What is a legal system? Before we define what a legal system is, let us first of all look at this important word found in the same legal system, a law. What is a law? A law is a set of rules that a society develops for it to control the behavior of its members towards one another. Set of rules. So when you put all those rules together, they make up what you call a law. That's a what? A law. Now, a legal system refers to the rules which make up laws. That means the laws are falling under what? The legal system. Apart from that, there is also the institutions that administer the laws under the same legal system, and the principles, procedures, and techniques that develop over the years in dealing with the law. All these things are falling under what you're calling the what? The legal system. The legal system. Courts are institutions that administer the law. They are falling under the legal system. Police service and the Zambia Police Service falling under what? Legal system. So a system comprises different things which are working together towards a common goal. Towards a common goal. So that is the legal system. Knowing what a legal system is, we would also like to know the elements of a good legal system. How can you know that this is a good legal system? So here are the things that we need to consider. 1. A good legal system must be simple. What do we mean? Here we talk about the language. The language used must be simple. It should be understood by every member of the society. 2. A good legal system must be comprehensive. It should not leave gaps. It should not leave gaps. It should tend to attempt all the areas of disputes. And it should also attempt the future problems. Future problems. For example, in the past, there was no homosexual. There was no homosexual. Now, because of technology, that act is developing. You see, it's developing. So, when forming up the legal system, it should cover the future problems. Not like when you see people performing homosexual, that's when you say, let us make a law prohibiting homosexual. No. That means the legal system is leaving what? Gaps. It should be certain. It should be certain. Citizens must know what is prohibited by the law. The law should not be ambiguous such that it is only being explained by a few members of the society. No, it should be certain. It must be accessible. That means available to people. Some people have never seen the Constitution. So the good legal system must be accessible, available to the people. It must be flexible, should change with time. This one is a bit similar to the second one, comprehensive. Flexible, it should be changing with time. New cases, new disputes which are arising should be facing or should be being provided for by the what? By the legal system. Things that were not there in the past, when they start existing, the constitution or the legal system should be flexible and change to cater for the new disputes which have arisen in the society. The last one is the moral values. A good legal system should reflect the moral values of a society. What is prohibited by the society should be prohibited by the legal system. What is accepted by the society must be accepted by the good legal system. For example, the society says adultery is prohibited, but the legal system is allowing or permitting adultery. Then that's not a good legal system. A good legal system must be reflecting the moral values of the society. Those are the elements of a good legal system. Good. Sources of law in Zambia. Sources of law. One, we have the English common law. This one started from the customs which were common to all parts of England. Some may wonder how. This happened in 1066 AD when King William the Conqueror united England. So what he did, he sent judges to collect cases from the citizens and to codify them into one single formal instrument. So from that act, common rule of law were identified, and they were referred to as English common law. English common law. Now, England imposed those laws on its colonies, the countries which were colonized by it at that time, and Zambia was one of them. So that's how the English common law came to Zambia. Two, we have legislation. This is the largest source of law in Zambia. It involves law or laws enacted by parliament. It involves laws enacted by parliament. There are three types of laws made by the legislature. One, we have the Constitution. The Constitution is the supreme law of the land. That means any law not conforming to the Constitution is considered to be void, invalid. Considered to be invalid. Two, we have acts of parliament. These are laws which are made through bills made by parliament. Firstly, the process starts by presenting of the bill in parliament, which goes through three stages of reading. After that, the bill will be sent to the president for either assent or withhold assent. If the president assents the bill, it is gazetted and becomes a law. But if the president withholds his or her assent, the parliament has to debate or make changes to the bill. That means it will be sent back. The president has not assented the bill, has not allowed it to become a law. So it will be sent back to the parliament. Now, parliament can debate further or make changes to the bill, or send it back to the president in its original form. Now, that's a special case. When that happens, whereby the bill has been sent to the president in its original form, the thing that he prohibited, he did not assent. They have sent it back to him or her. The president has only 21 days in which to either assent the bill or dissolve parliament to pave way for new elections. Are we together there? 3, we have the delegated or the subsidiary laws. These are laws made by cabinet ministers. For example, a minister of education can make a law of abolishing the wearing of uniforms in schools. That is a delegated or subsidiary law. Number 3, we've got the case law. Case law is the second largest source of law in Zambia. After the legislation follows the case law. It is based on law reports or judicial reports. Now, how is this a source of law? When using case law, the court, when judging upon a certain case considers how the same case was decided upon in the superior court. In the superior court. For example, when you talk of the High Court, when the High Court is judging a case using case law, they will consider how that case was decided upon in the Supreme Court, because the Supreme Court is superior to the High Court. So the decisions made by the superior courts are recorded and reported in the law reports or the judicial reports. So those are the records that the small courts, or let's say the preceding courts use when judging. The preceding, we mean the court which is smaller than the bigger court. Don't know how I can explain this one, but I mean, when I talk of the High Court, the decisions of the High Court will be taken by the magistrate, because the magistrate is smaller than the High Court. High Court will be taking decisions of the what? The Supreme Court. That's how it is there. There they use what? Case law. On number 4, we have international treaties. As we know, Zambia has signed several international treaties. Now, some of the contents of these treaties are also sources of law, but they do not become laws immediately. They have to be domesticated by Parliament. International treaties. We go to customary law. This one is very simple, only based on customs of a society. Local courts use assessors when judging. We've got those elders who are asked to contribute or advise during the processes in the local courts. When the local courts are judging, they are advised by the elders. Those elders are referred to as the assessors. So the laws of the customary, or let me say the laws in the customary, they are not written, they are not codified in one document. They are just rules. They are not written. So it is based on customs of a society. We now go to criminal and civil cases. Of the two, a criminal case is a bit complicated, so I'll start with the simplest one, the civil case. Before I explain the civil case, I would like to know, or we would like to know, what a case is. A case is a matter being examined. Just a matter being examined or judged in a court of law. That's a case. Now, we've got a civil case. This is a wrongful act that affects only individuals involved. A wrongful act that affects only individuals involved. For example, failing to settle a debt, credits. This does not affect the whole society. It only affects individuals involved. That's a civil case. We now go to a criminal case. Criminal cases deal with crimes. What is a crime? A crime is a wrongful act that affects the interest of the society. It affects the interest of the society, unlike in the civil case, where only parties involved are the ones which are or who are affected. But for a crime, the whole society is affected. For example, theft, adultery, murder. Those cases affect the interest of the whole society. That's why you see the community beating up a thief, because their interest is affected that time. We got to the elements of a crime. Every crime has two elements. Two. The first one is the intention or desire to cause harm. Intention or desire to cause harm. This involves planning or having thoughts of causing harm. Did you intend to do what you have done? Did you have thoughts on performing the action that you have just done. We call this in Latin as mens rea. Mens rea. We remove the a there. It says mens rea. Mens rea. So they ask. In Latin, it's known as mens rea. That's the intention or desire to harm. The second one is the wrongful act itself now. The wrongful act. This is referred to as actus reus in Latin. Actus reus. The wrongful act. So now, let me explain something here. We've got murder and manslaughter. Murder and manslaughter. What's the difference between the two? When you plan to say, I'll go and kill Mr. Gilbert, and you have done the action of killing, that is what? Murder. Involving the intention or the mens rea. You planned, you intended to do that, and you have performed the what? The wrongful action. So they will look for the action. What did you use? I used the knife. Knife? You stabbed him. So that's the what? That's the wrongful act. The stabbing. It's the wrongful act. The actus reus. The mens rea, the planning. That's murder. Now, let us take it for instance. You're driving a car. Then, all of a sudden, the car has lost control. The car has lost control. And then you hit the person and he or she dies. Is that murder? Is that murder? Students, is that murder? Oh, so see, you have killed the person. But that's not murder. That's manslaughter. Because you did not intend to kill that person. It wasn't your intention to say, I'm going to hit someone today. No, it wasn't your intention. But the wrongful act is there, but the intention is not there. The mens rea is not there. The mens rea is not there. Are we together there? We now go to the classification of these crimes now. They are classified into two classes, first of all. One, we have crimes of specific intent and crimes of basic intent. Don't confuse the two. Those which we were just from talking about are the elements of a crime. Now here we are classifying the crimes. Crimes of specific intent. What are these? These are crimes committed with a specific intention. You just intended to do that. It was your plan. For example, wounding someone to cause grievous harm, or theft, burglary, and robbery. You cannot say, I just stole just by accidentally. Stealing, how can you steal someone accidentally? Or steal something, accidentally. Robber. The robbers, they plan to say, we will rob that bank today. See? They rob. That means that's a crime of specific intent. Here we can also put rape case. Rape case defilement. You cannot say, I just raped her accidentally. Accidentally how? You planned to say, I'll do that and that. It started from your mind. The mind started, planned it all, and then the action came. Those are crimes of specific intent. We have crimes of basic intent. These are crimes committed through recklessness or on a sudden impulse. You are not intending to do that, but it has just happened all of a sudden. For example, exceeding the speed limit. Exceeding the speed limit. You may find that maybe just from an impulse, you have exceeded the what? The speed limit. Or not stopping at a stop sign. Or manslaughter. I've explained about manslaughter. So manslaughter, all those are crimes of basic intent. You did not intend to do that, but you have just found yourself doing the action. Those are crimes of basic intent. But the same crimes can further be classified into three classes again. Three classes. So do not confuse this. Make sure you understand the question when it comes in an exam. You know what you're talking about here. So let us look at the three further classes of crimes. The first one is the misdemeanors. The misdemeanors. What are these? These are petty crimes, small crimes, such as assault, indecent exposure, pickpocketing, or littering. Those small crimes are known as misdemeanors crimes. 2, we have felonies. Felonies are serious crimes such as murder, treason, aggravated robbery, defilement, or rape case. Or rape. Some may wonder about treason. Maybe let me explain about treason. Treason is simply putting, let me just say, the life of the president at stake. Putting the state house in danger or at stake. Anything attempting to put danger to the president, then that's treason. For example, blocking the way for the president. He's going somewhere, then you block his way. That's treason. You are putting him in danger. So we keep hearing these cases in news. Treason. Some of us don't even know. Okay, so that is it. Treason. We have statutory crimes. Statutory crimes are those crimes committed contrary to what is contained in the statutory instruments. For example, the Constitution says every citizen must vote once in an election. Now you just vote twice. You vote twice in one election. That's a statutory crime. Rigging elections, statutory crimes. Failing to pay tax, statutory crimes. As long as you commit a crime that is contrary to what is contained in the statutory instruments. Statutory instruments, we're talking about the Constitution here. Now, let us try to look at some of the differences between a criminal case and a civil case. Criminal case and a civil case. So it's like one this side pairing with another one that side on the civil case. So, number one, on the criminal case. A criminal case affects the whole community or affects the interest of the whole community. One, on the civil case, affects only parties involved. Only parties involved. So for a criminal case, it is recorded as People versus Chilufya. People versus Chilufya. That's just a name there. That's just the name, showing that it's people versus one person. But here on the civil case, it's Chipo versus Cholwe. Person. Just parties involved. 2. A criminal case ends in sentencing the offender. Sentencing, putting in jail. But for a civil case, it ends in awarding damages to the offended. You award damages to the offended. If you are not settled the debts, they will just say, when can you be able to pay the debts? The court will just ensure that you pay the debts, you fulfill your promises. That's how it is. 3. A criminal case is a serious wrongful act. A civil case is a less serious wrongful act. For the aim of the court in a criminal case is to punish and reform the offender. To punish and reform the offender. Now, during a civil case, the aim of the court is to compensate the wronged person. So, it will just make sure that you compensate the person you have wronged. Those are some of the differences. This is a video. So, research more. There are so many differences. I've just laid down 4 there. You can find that in the exam they say 6. And you'll be disadvantaged. So, make sure you have everything with you when going in an exam. Good.